Hi there, welcome to the latest episode of my 10-minute moan. And the topic of this 10-minute moan is an old story, but one that not everyone will know, and it's one that I've been meaning to do a video about for some time. And that topic is Keir Starmer and his part in allowing all sex offenders not automatically to go to jail. Now, this story was covered back in, I think it was April last year by the Daily Mail, and I've also going to refer to another 3 stories with some slightly additional bits of information that they ran with since then. So back in April last year, the headline was "Not just dishonest but deeply hypocritical. Guy Adams investigates how after Keir Starmer went to 21 meetings of the Sentencing Council, it decided that not all child sex offenders should go to prison." Sir Keir went to 21 of the 23 meetings which formulated sexual offences sentencing. The council decided 20 sexual crimes could be punished via community orders. In April the 8th, 2011, Keir Starmer joined some of Britain's top legal eagles at a monthly meeting of the Sentencing Council, the ultra-powerful quango that tells judges and magistrates how convicted criminals ought to be punished. It was all in a day's work for our then Director of Public Prosecutions, who was joined by 12 fellow members of the committee, plus no fewer than 15 officials and observers, around what must have been one of Britain's longest conference tables. Issues they discussed ranged from the media coverage of a recent consultation in drug sentencing, which had seen members attacked for their alleged liberal bias, to proper tariffs for burglary, assault and antisocial behaviour. But it was the 7th item on the agenda that, for Starmer at least, would eventually prove to be the most controversial. Minutes of the gathering, which was chaired by Sir Brian Levison of the Press Inquiry fame, show that Sir Keir and his fellow members were presented with the initial findings of a review into current sentencing practice for sexual offences. It was the start of a lengthy process that would end 3 years down the line with a series of dramatic and some might say woefully misguided changes to the way in which our courts in England and Wales deal with the most heinous of crimes. During that period, Sir Keir attended 21 of the 23 meetings at which the Sentencing Council formulated new guidelines related to 50 different sexual offences. The crimes that were looked at during the review ranged from rape and sexual assault to prostitution, grooming, sex trafficking, voyeurism and exposure, and child pornography. Eventually, the council decided that 20 of these crimes could, in certain circumstances, be punished via community orders rather than prison sentences. That number included a total of 8 offences where the principal victim was a child. They ranged from sexual assault of a child under 13, to possession of an indecent photograph of a child, to paying for the sexual services of a child, and arranging or facilitating the sexual exploitation of a child. Now, I'll just pause at this point because I think the bit about possession of indecent photographs of a child being punishable by non-custodial sentences is quite worrying, because obviously what happened this week in the court with our BBC presenter. But when you look at the list of these offences, and you think, who in their right mind would think that having sexual assault of a child under 13 could be punishable by anything other than a custodial sentence? Paying for the sexual services of a child could lead to a sentence of community service. And arranging or facilitating the sexual exploitation of a child. So that would mean like hawking out kids for other people's sexual pleasure. Does not involve and does not need to involve a custodial sentence. It's actually sick. However, this all happened on Sir Keir's watch, and there's absolutely no evidence that he ever objected to any of these remarkably soft sentencing guidelines, which took effect in April 2014. At no point did he publicly voice so much as a flicker of concern about the fact that introducing them could result in a significant number of child sex offenders been spared prison. And if the earnest Director of Public Prosecutions happened to voice any scepticism in more private forum, for example during any of the 21 Sentencing Council meetings listed above, those remarks failed to find their way into any of the official minutes that were subsequently published, all of which have now been reviewed by the Mail. In other words, one might fairly argue that Starmer bears significant responsibility for the fact that from 2014 until the present day, it's been possible for child sex offenders who come before the courts in England and Wales to avoid jail. Yet fast forward to last Thursday, this is obviously 2023, and the same Keir Starmer could be found claiming voters ought to somehow blame Rishi Sunak for this regrettable state of affairs. In what Labour grandee David Blunkett derided as gutter attack, the leader of the opposition presided over Labour's official Twitter account, cynically asking a rhetorical question. Do you think adults convicted of sexually assaulting children should go to prison? Rishi Sunak doesn't. The post illustrated with Sunak photo and signature sought to justify the allegation by noting that 4,500 adults convicted of sexually assaulting children served no prison time since the Conservatives took office. In truth, as it happens, is that Sunak bears little responsibility for this statistic. He wasn't even an MP until 2015. And under British law, it's judges and magistrates rather than politicians who decide whether individual crimes ought to go to prison. Starmer's decision to go on the offensive on this front is just not dishonest, but is deeply hypocritical. For the Labour leader's own track record gives every indication that he, rather than the Prime Minister, is the one who takes the view child sex offenders ought to be spared jail. You can see this pertinent fact laid bare in black and white by browsing through the Sentencing Council Sexual Offences Guideline consultation issued from its office at the Royal Courts of Justice in December 2012. Spanning 370 pages, its publication followed discussions that had been taken at no fewer than 15 monthly meetings that Starmer had attended in person over the previous 18 months. The contents of the consultation also formed the basis of new guidelines that were issued 2 years later and have largely been in place ever since. The document makes clear during the opening pages of its introduction that Starmer and his colleagues in the Council had decided that certain sexual crimes were insufficiently serious to justify a custodial sentence. The Council believes, the document states, that in some cases both the victim and the public will be better protected by the imposition of a punishment in the form of a rigorous community order, with programmes which challenge offenders to change their behaviour and, above all, not to re-offend. It goes on to list various crimes that Starmer and fellow members of the Council reckon should be punished via community orders. These included offences: assault by penetration, sexual activity with a child, sexual assault of a child under 13, causing or inciting a child to indulge in sexual activity, inciting a child family member to engage in sexual activity, causing a child to watch a sexual act, the possession of indecent photographs of children, and arranging or facilitating child prostitution or pornography. Now, just on that point, there is no such thing as child pornography. Because if you think what has to take place before those images or videos are produced, there's a child being sexually assaulted. So this word of child pornography to me is a bit odd, in the same as the other one, which was, where was it? Possession of indecent photographs of children. That's not technically true. These are photographs of children being sexually abused, even if it's just to be asked to become naked so someone can photograph them. That's sexual abuse of a child. Hopefully the consultation document, which, let us remember, was produced during Starmer's time in the Council, then lists a number of scenarios in which judges might choose to impose non-custodial sentence for sex offenders. For example, a judge sentencing an offender convicted of spying on women in community changing rooms with a hidden camera, which is voyeurism, may decide to impose a community order of up to 3 years, reads one such case study. Another scenario proposed an indecent An incident, where an offender approaches a woman at a crowded bus stop and grabs her breasts over her clothing. The document continues, the offender has no previous convictions. I'm just going to scan. Child sex offences are crucially among those which should in some circumstances be dealt with via community orders. The document released in Starmer's watch continues so long as the crime is non-penetrative. This particularly applies in cases where there's no evidence of grooming or exploitation or significant disparity in age. Any sexual abuse of a child is exploitation. This beggars belief. So it goes that a crime cited in the document involves a case where an 18-year-old male au pair lives with a family and is responsible for being in sole charge of a 14-year-old girl after school, driving her home from school and cooking dinner. The au pair and girl become close and are caught by the parents in a state of undress, kissing and touching each other. I can't read much more of this. Anyway, that's the first article, which was from the Mail, which I read almost in its entirety. I have no reason to do so for the rest of them, and that was published in April last year. We've got another couple of things I just want to skim over. This was around about the same time, April last year. This one was, try to do them in sort of chronological order. That one was December, so that would be after that. And this other blog, yeah, so the two blogs were April the same year, both in a place called the Squank Box, which I'm not really sure what it is. Starmer asked judge to hide paedophiles' identity and leniency of sentence. Keir Starmer has rightly been under fire since Labour have been exploited abused children by publishing Twitter posts claiming Rishi Sunak doesn't care about protecting children, blah, blah, blah. And this goes to when he was a Criminal Prosecution Service lead in 2013. He was asked to explain why murderers and rapists were escaping conviction and were not sending caseworkers or enough barristers to court proceedings. Mr. Starmer told a judge, this was when he was defending, there's a real risk of physical attack if his name and his images are shown with adverse comment about the leniency of his sentence, because this was about a sexual predator who achieved no custodial, and Starmer wanted to keep his name out the public because it would be dangerous for him. This other story, again in the same outlet, Starmer's child abuse sentence and attack explodes in his face. He wrote the sentencing guidelines. So they're taking a step further in suggestion not only was he at all these meetings of this group, but he in fact had written out some of the sentencing guidelines. And then the most recent, which was December that year, and it's a piece in The Guardian. There is a reason Starmer is under fire for his record as a lawyer, and good reason he should defend it. And again, it's going on about using his past for political benefit. Where is a bit? Between 2008 and 2013, Starmer was responsible for criminal prosecutions in England and Wales. He oversaw many controversial cases as well as many decisions not to prosecute. One of the most controversial cases during his tenure was that of Jimmy Savile, the DJ and TV presenter who escaped justice for the sexual abuse and rape of children, even though a string of victims came forward to report his crimes. When Boris Johnson was Prime Minister, he said the failure to take action against Savile proved the former DPP was soft on paedophiles. This was regarded as a particularly low blow, as Starmer had no personal involvement in the case. Nevertheless, the charge partly stuck because he was in charge of prosecutions. That's why it stuck. Anyway, that's the amazing, some of the amazing connections to Keir Starmer, the law and order based around paedophiles. And I find it absolutely incredible that a man who looks as if, according to one source, was not only part of the committee that wrote the guidelines on non-custodial sentences for sexual crimes, including those at children, but some are suggesting he actually wrote them. And then there's a suggestion about some high-profile cases when he was the head of prosecution services that surprisingly never made court. And I find it bizarre because yet again we have a person who publicly falls on the side of the trans rights movement, having slightly similar views about paedophiles, where the majority of people I know would consider a paedophile some of the most heinous crimes possible. Yet Keir Starmer is in this group of people who think, well, sometimes they don't need to go to prison, and funnily enough, tends to agree with the trans rights movement and a lot of things, and these things often go hand in hand. And we've seen people trying not to use the word paedophile. We should be using minor attracted person, because to use the word paedophile might offend some paedophiles. Well, I think I'll probably not use the word minor attracted persons when I'm discussing and describing people who sexually abuse children. I think I would rather use the word paedophile. And it's slightly better than the often used terminology of beast. I'll stick to paedophile if that's okay with society. If you enjoyed this video, please give it a thumbs up. If you've not already done so, please consider subscribing and hitting the notifications bell. Please leave your comments below. But most importantly of all, unless you're Keir Starmer, people who are paedophiles or people who want to protect them with lenient sentences and keeping their names out the public. Not you, but
everyone else. Have a great day. Cheerio, bye now.